Welcome once again to Lehto's Law. Here's Steve Lehto.
This is going to be a longer video, for which I apologize now. I've got some people who complain about long videos, but I have to do this because I'm going to deconstruct the lawsuit, the complaint that was filed in Ohio regarding the Ford Explorer, which spontaneously combusted in an insurance company on behalf of the police departments filed a lawsuit against Ford Motor Company, saying that the Ford Explorer that was purchased by the police department was defective. And as a result, they filed a lawsuit. And I did a video a couple days ago where I mentioned that that lawsuit's been filed, and one of the claims was the Lemon Law. And Ford had gone to court and said, well, technically speaking, under Ohio law, the Ford Explorer is not a motor vehicle, as defined in that particular law. So they've asked for that one count to be thrown out of the complaint. So I mentioned in that video I hadn't seen the complaint yet, and Vincent sent me a note. So Steve, I dug it up for you. Here you go. And sent me a PDF of the complaint. So I've got it in my hand here, and we'll discuss the things I find noteworthy in it. But I had nothing to do with the drafting of this complaint. Nobody ever calls me before they draft a complaint. So this is a fair game for me. In the Court of Common Pleas, Butler County, Ohio, case number CV2023-02-0264, Ohio Township Association Risk Management Authority, which is headquartered in Southfield, Michigan. In fact, their office is right on the corner from my office. So I did not know that, but this is a risk management authority. It's an insurance company of sorts, and they are the Subrogation and NHTSA of Westchester Township, Ohio. So they are standing in the shoes of that police department versus Ford Motor Company and a dealership and two different other companies that I believe did work on the vehicle. And we're going to get to that because I mentioned that in the video. I speculated about something. It turns out I was right. But this is the first amended complaint because the complaint's been amended once. When you file a lawsuit, if you decide that you need to actually modify or change the lawsuit after you filed it, most states will pretty much give you one shot at amending the complaint so long as you do it early enough to where it doesn't prejudice the other side. You can also often amend your complaint later if the court deems there's a defect in the complaint, but you say, hey, I can fix it if you let me amend it. You can almost also always amend your complaint if the other side will let you. So in other words, you can contact us and, hey, can I amend my complaint? I have an issue here, whatever. And if they say yes, you can usually do that by stipulation. However, if the other side won't let you and says, no, we won't stipulate that, you can then usually file a motion and ask for leave to amend a complaint. I've seen a fourth amended complaint. I've seen a fifth amended complaint. So it does happen sometimes, more often than others. So again, the people being sued here are the Ford Motor Company, the Ford dealership, a company that sells safety equipment, and another company that did some work on the vehicle. So in the complaint itself, one of the captions says nature of case, and they describe it as a product liability, deceptive trade practices, and negligence action. By this action, we seek money damages against defendants arising from Ford's and the dealership's design, manufacture, and distribution of a vehicle that experienced a spontaneous engine fire because of a defectively designed and or manufactured exhaust system and or other engine or vehicle components from defendants' deceptive trade practices and otherwise from defendants' negligent acts and or omissions which directly and proximately caused the Explorer to be destroyed. So they're basically saying, look, we got a couple things going on here. One of them is a product liability claim. One of them is a deceptive trade practices claim, or like I've talked before about consumer protection laws. And then, of course, negligence and a few other things that are tangentially related, as I like to say. They do say on information and belief, and then they say some other things. And here is interesting because they often say that they believe these things happened and they hope to be able to prove them after discovery has taken place. So they're admitting right now that they cannot point to the component that caused the failure. But they're hoping they can do so after they get involved in the lawsuit and they can subpoena documents, request documents, or take take depositions or send interrogatories, and that they can get this information from the other side. So they're saying that much of what they're doing here is based on what they believe to be true, and they're hoping to prove it later. And that's perfectly allowable. The question is, after all the discovery is done, will they then be able to point to and say, okay, that's the problem, or that was the problem? They say that more specifically, the exhaust system and or the engine or vehicle components of the Explorer were designed and or manufactured in such a way that the risk of overheating was unreasonably increased. So they're saying it was an overheating problem, which you might know in automotive terms, overheating is a little different than things under the engine getting hot. Overheating is often a reference to the cooling system, but I understand that sometimes these people plead very, very vaguely, so we'll go with that. In this instance, the overheating caused the Explorer's engine to spontaneously combust. And the use of the word spontaneously combust, I don't know why it bothers me, because I think of the Weekly World News and the headlines about a man sitting in his chair watching television and then spontaneously combusting. The X-Files may have had a couple episodes about that too. But the spontaneous combustion implies that it just kind of, like on its own. And so they do say that on information and belief, defendants could have designed, manufactured, and distributed the Explorer without the defect, but chose not to do so. Oh, boy. Yeah, I'm not sure that actually is the best way to plead that either, because you're implying that they knew about this. And so if I was a Ford attorney, I would circle the chose not to do so and send over an interrogatory that says, could you please explain to us the factual basis for making the argument that we knew about this and chose not to do anything about it? Because chose is a actual action. To choose is an action taken by somebody. It says, indeed, other vehicles designed, manufactured, and distributed by Ford and the dealership have exhaust systems and or other engine or vehicle components that do not unreasonably increase the risk of overheating to the point where the vehicle might spontaneously combust. So they're basically saying ours caught on fire and others do not. Therefore, that proves there is something wrong with ours that Ford chose not to do. And again, same paragraph number 4. 5, the dealers and the manufacturer's decision to design, manufacture, and distribute the Explorer with the defect has not only caused damages, and they go on and on. And again, now they're implying that Ford knew of the defect along with the dealership before it was sold. And again, I'd love to know what evidence you have of that after discovery, of course. Now, the police department purchased the Explorer from the dealership, and on the first day it was used by the department, it did catch on fire, and the Explorer was destroyed. So that's an important fact to know. On information and belief, defendants engaged in a deceptive trade practice when, in the course of their business, they represented to the police department that the Explorer was of a particular standard, quality, or grade when it was of another. They're using terminology from their Unfair and Deceptive Trade Practices Act there. So they can say that the dealership which sold the vehicle and Ford which manufactured it were being deceptive, and therefore it violated that statute. You might say, why does that matter? That statute allows for the recovery of attorney fees and court costs if these people succeed. So therefore, they want to get their attorney fees paid. More specifically, Ford and the dealership represented that the Explorer was designed and manufactured and distributed without the defect, which could and in fact did cause the vehicle's engine to spontaneously combust. And it makes it almost sound like Ford said specifically, this thing will not blow up. And I have a hard time believing they ever actually did that. Additionally, at paragraph 9, prior to the Explorer being put into service, a company, another defendant, installed lighting and or police equipment on the Explorer, and another company installed reflective vinyl on the Explorer. They've named both of those parties as defendants. Now, installing the reflective vinyl, I'm not exactly sure where that is, but it's probably down the side of the car. It says, Westchester Police Department in reflective letters. But the lighting and or police equipment was installed by a third party. And I mentioned that in my video, and I said that I believe that the vehicles are shipped by Ford Motor Company, and then later other people modify them. And I had a few people push back on that and say, Steve, no. Ford makes a police version of the Explorer. It comes equipped. Well, no, they do make a Ford police version. There's no question about that. But when it gets shipped to the police departments routinely then have to do what they want done with it, which includes installing lighting and or police equipment, as was done here by another company. And I was getting at that yesterday because it's an extremely common defense in lemon law claims. If somebody's made any modification to the vehicle, the manufacturer of the vehicle can go, look, we shipped it fine. It's those modifications that caused those problems. And so I'm not saying that is what happened. I'm simply saying that allegation will be raised in defense to these claims. So when I speculated the other day that there may have been a third party involved here, turns out I was right. So fun to point that out. More specifically, the two companies negligently installed lighting, police equipment, and reflective vinyl, or otherwise tampered with the Explorer, either intentionally or negligently, causing the Explorer's exhaust system and or engine or vehicle components to overheat to the point where the engine spontaneously caught fire. Now, the fascinating thing there is they don't mention Ford Motor Company in that paragraph. So they appear to be saying it could have been Ford, or it could have been these guys, or it could have been both, I guess. Another part of the complaint describes the parties, which is quite common. It says where they're located and what they do. Another part of the complaint talks about jurisdiction and venue as to why it's filed in this court. But then in the factual allegations, it describes the defect at paragraph 24 on information and belief and subject to additional information learned after obtaining discovery from defendants and or third parties. The defect is the result of the design and or manufacture of the exhaust system and or other engine or vehicle components. In the Explorer, the exhaust system is insufficiently separated or segregated from other engine components. By the way, remember that the guy reading this to you right now has owned 5 or 6 Explorers and currently owns 2. On information and belief, the lack of adequate separation or segregation between the exhaust system and other components created unreasonably high temperatures in the catalytic converter and other parts of the engine block. See, the use of the word other implies that they believe the catalytic converter is part of the engine block. Unreasonably high temperatures in the catalytic converter and other parts of the engine block, when they could have just said and parts of the engine block. Such high temperatures unreasonably increased the risk of engine fire and caused the Explorer to spontaneously combust without warning. In the alternative, and subject to discovery, other design and or manufacturing deficiencies created unreasonably high temperatures in the catalytic converter and other parts of the engine block. Such high temperatures unreasonably increased the risk of engine fire and caused the Explorer to spontaneously combust without warning. See, this is one of the fun things. I've talked to people as recently as last week. Somebody said, Steve, why did you get into lemon law as opposed to another field of law? And I said, well, it was one of the ways that I could talk about cars all day long and make a living. And I'm partly joking, but I'm also partly telling the truth there. Because I've read complaints written by people who don't understand cars, and they'll say things like that. The catalytic converter and other parts of the engine block. Catalytic converters back there. The engine's over there. Okay? Now, they are connected the same way that your elbow bone's connected to your arm bone, but it's not part of the engine block. And so when you read that, somebody who knows anything about cars would have said, well, you should probably remove some of these words, move this around a little bit to make it look like you know what you're talking about. It might help. But because of the defect, plaintiffs have been forced to expend time and money dealing with the Explorer and dealing with all this, and they talk about damages. They tell the story that on January 8th of 2021, they bought the Explorer, and after it was purchased, they had the work done on it by the 2 vendors who did work on it after they bought it. And after it was purchased, one company installed the vinyl, and one company apparently installed all the electronics, the lighting equipment, and so on. On May 31st, the Explorer was put into service. On that day, it was driven for one shift by one officer. Second shift, another officer got in it, went to his first call, and while there, it almost immediately burst into flames. And so there's no question that there appears to have been something wrong with this vehicle because it blew up at about 150 miles. So the complaint does contain a whole bunch of photographs and point out that the odometer had a reading of about 150 miles. Now, here is the thing. It says that the insurance company steps in and became subrogated to all the rights of recovery that Westchester Township possesses against defendants. And they also point out that the Township Police Department had to incur an expense of $500 for a deductible. And they then notified Ford Motor Company of the defect in the car. And they said, since being so notified, defendants have not taken any steps to attempt to resolve the defect or the claims alleged herein. So they say we contacted Ford, and Ford said, don't know what to do, we can't help you. Okay, so sub C at paragraph 52 says the defect posed a safety risk to drivers of the Explorer, passengers in the Explorer, and others. So the defect that they keep referring to is whatever led to the overheating, which they say they're not quite sure what it is, but they hope to discover it in discovery. It says, Now, here is one of the things where I think this complaint goes off the rails. I've never seen this in a complaint before. I've been practicing law for 32 years. I've drafted too many complaints to count. I've never seen this. As detailed further below, the National Highway Traffic Safety Administration, or NHTSA, is replete with complaints of smoking vehicles and engine fires that often result in a total loss of the vehicle. That paragraph is irrelevant. They're basically saying that people complain to NHTSA about cars that smoke and burn. Okay, what's it got to do with Ford Motor Company? What's it got to do with your client? What's it got to do with this vehicle? And you're going to say, well, Steve, obviously they're setting something up. Well, I suppose you could, but this isn't like a novel where we're trying to set the scene. Every allegation in the complaint is supposed to be directly relevant to the claims you're making. And so someone could argue and say, that's irrelevant to this case, that people complain to NHTSA about smoking cars and burning cars. I hope they do. I think that's what NHTSA's job is, to take those complaints. Do any of them involve Ford Motor Company? Well, the next paragraph, one does. Here's an example. One complaint filed with the National Highway Traffic Safety Administration detailed an individual's experience while driving a 2017 Ford Edge. Well, this case doesn't involve a 2017 Ford Edge, does it? So how is another type of vehicle catching on fire relevant to this one? Does the Ford Edge use the same powertrain as the Explorer at issue in this case? Paragraph 56, another example from the NHTSA details an individual's experience while driving a 2012 Ford Taurus. In that instance, the driver was sitting at a stop sign when the engine caught fire spontaneously and burned the top of the engine compartment and hood of the vehicle. Another example details an individual's experience while driving a 2019 Lincoln MKC manufactured by Ford. Again, all of these cases are irrelevant. Some people might point out that they're hearsay, and some people might point out that why are they here? Why are you dragging all this stuff out? Because I assure you that cars catch on fire from time to time for all kinds of reasons. And it can be a manufacturing defect, it can be a design defect, or it could be that one of these people here just mentioned had taken their car to a backyard mechanic who did a bad job on it and screwed something up. We don't know. Because I'm sure you'd know if you'd poked around that each one of these complaints potentially could have led to an investigation. Did they? And if so, what were the results of the investigation? They didn't do that. 58, another example from NHTSA details an individual's experience while driving a 2017 Ford Explorer. Oh, is that same as the one in this case? No, it's not. Another example details an individual's experience while driving a 2014 Ford F-150 with his children in the vehicle. Paragraph 60, another example, an individual's experience while driving a 2014 Ford Escape, a Ford Escape. Another example from NHTSA details an individual's experience while driving a 2016 Ford F-150 where the driver was just 5 miles from his destination. Oh boy, that sounds horrible. In addition to the vehicle fires that have occurred in vehicles manufactured by Ford, Ford issued an under-hood fire recall in May 2022 on 2021 Ford Expeditions and 2021 Lincoln Navigators. Did they do it on the Explorer? Apparently not. I'm assuming if they had, they would have mentioned it, right? In November of 2022, Ford also issued a recall over fire risks from possible cracked fuel injectors on Bronco Sport and Escape SUVs, neither of which are Explorers. And those recalls were in fact limited to the Bronco Sport and the Escape SUVs. So why are all of these paragraphs in here of unrelated cases? I'm not quite sure. I'm sure the average person who skims this would go, wow, Ford's got a lot of vehicles going up in flames. I could do the exact same search for Chrysler or General Motors and find vehicle engine fires for a lot of different manufacturers out there. The fact that a Ford Bronco Sport was recalled for a bad fuel injector does not have anything to do with this Ford Explorer owned by the police department going up in flames. Zero. So some people might note that this appears to be extraneous pleading, meaning it's stuff put in the pleadings that doesn't belong there. Then it goes into another section. Ford and the dealership knew or should have known that the Explorer was defectively designed and or manufactured. And this is an important distinction. If I build something and I give it to you and it bursts into flames, that could happen for a variety of reasons, one of which could be a bad design, which would hint that yours probably isn't the only one, because if I manufacture all these things to the same specs and the overall design is bad, many of them would have the same problem. Whether that problem leads to fires is another thing altogether. But the point is that if it's defectively designed, you look at the designs and you look at the fires and go, is there a connection here? If it's a defective manufacturing process or defective manufactured part, that might be a one-off, or it might be a couple of different things. But again, to say that they knew or should have known means that if it's a design problem, they should have spotted that. And of course, that would make more sense. But if there's a one-off part in there sent to them by a vendor and it's a hard-to-spot problem, should they have known that? Well, the question is whether they knew or should have known. They're getting here at negligence, okay, and whether or not Ford or the dealership has got a duty to notify you that they've sold you something that's defective. They say in light of the history of Ford vehicle fires, defendants knew or should have known that the Explorer had the defect and could spontaneously catch fire while being used for the purposes for which they're intended by defendants. I'm not a logic professor, but I do actually know one. And I'm going to tell you right now that I said to him, Tom, there's a whole bunch of different vehicles that have nothing to do with this case that caught on fire. And then I make the statement, in light of the history of Ford vehicle fires, defendants Ford and the dealership knew or should have known that the Explorer had the defect. What's the problem with the logic there? Well, none of the examples you gave were of this type of vehicle in this year. So how would they draw the conclusion that they know something when their sample size is 0? Additionally, and on information and belief, Ford would have gained comprehensive and exclusive knowledge about the potential for these issues during their designing, manufacturing, and testing of the Explorer. Oh, that's true. If, in fact, that, this happened, then they would have had information. But on information and belief, adequate pre-release analysis of the design, engineering, and manufacturing of the exhaust system and or other engine or vehicle components of the Explorer would have revealed to Ford that the design, engineering, and or manufacturing of the Explorer created the defect and the possibility for unreasonable high temperatures in the catalytic converter and or other parts of the engine block. Sorry. Ford and the dealership made representations about the character, quality, and safety of the Explorer, so they're going to get there into some other things. But they start with a product liability claim. And you have to understand that not every state has got a product liability cause of action. Some states make you go in under a warranty claim or a negligence claim, but apparently Ohio has a specific product liability statute. And so there, if you can prove that a product was put in the stream of commerce that was by its very nature dangerous, that you can then go after them for harm it's caused. The question is whether or not you can prove that this product was in fact dangerous when shipped by Ford Motor Company. And they say that they can do that upon information and belief. They do claim that the Explorer was defectively designed, and so to make that allegation, they'll get to prove that in court, and if it goes that far, they'll get to try that. Meanwhile, they did say count 2 is negligence. And I've mentioned before that negligence arises from a duty. If you have a duty to somebody and you breach that duty and they're harmed by that breach, then you can owe them damages. Best example I can give you is I have a duty to drive my car in a safe and reasonable manner. So if I run a red light and plow into your car and harm you, I've been negligent in how I've been driving my car. That would be an auto negligence claim. And that would be my breach of that duty and harmed you. So they're saying here that Ford Motor Company and the dealership had a duty to not design, manufacture, and distribute vehicles capable of spontaneous engine fires. That's written backwards. They should actually say they've got a duty to design safe and reliable transportation. But I guess if they want to put it that way and say they have a duty to not design one that bursts into flames, I guess they can do that, but they're going to have a harder time, I think, finding case law that says that, yes, you've got a duty to not design a vehicle that unreasonably overheats its engine block and or catalytic converter. They also say there's a failure to warn here. And they're talking about that Ford should have warned somebody that this is going to happen. Which assumes they had prior notice. And I've got no problem with that. If, in fact, Ford knew about this and you can prove it, then them not explaining that to people might be something. that you can do, but the question is, can you prove that out after discovery? Now, here's the thing. In my video the other day, I said specifically that the Lemon Law claim was not the strongest claim there because it appears to not apply. However, I said what they should probably do is be going under some UCC claims, Uniform Commercial Code, which applies to sale of goods. And breach of warranty is the obvious one. So I would have said breach of warranty, express, breach of warranty, implied warranty, and merchantability. And then I would have said breach of warranty of fitness for a particular purpose, which is the only one of those three they pled. Count 4 at paragraph 103. Breach of the implied warranty of fitness for a particular purpose. And they talk about how that the police department went to the dealership and said, we need this vehicle to be a police vehicle. And that Ford knew that because Ford sells police vehicles. And the dealership knew that. And so they got this vehicle for that purpose. And because they knew of that purpose, it should be held to a higher standard. And that's fine. That's not a bad argument to be made here. However, breach of express warranty is somehow lacking here. It's not here. It ought to be here. Because as you know, when you buy a brand new vehicle in America, you get a glove box warranty. And the glove box warranty is what says that this vehicle is covered bumper to bumper, 3 years, 36,000 miles, or whatever. And that description of a warranty is called a glove box warranty. It is an express warranty made by both the manufacturer and possibly by the seller. However, most sellers disclaim them. But it still does speak to Ford Motor Company that if you read the warranty booklet that came with this Explorer, it'll say if there's a defect in materials or workmanship, we will, in essence, remedy that for you at no cost to you once you notify us of it. So when the car goes up in smoke and they notify Ford, Ford is duty bound to honor that warranty unless it didn't arise because of a defect in materials or workmanship. So it's possible Ford is going to take the position to say it's not our fault. It's whoever tampered with the electronics and the wiring in this vehicle. That could be what they're going to say. I'm just pointing that out. The allegation is so easy to make, and that's the easiest of the warranties to prove because you can point to the glove box and go, before that car burned, there was a warranty in there, which you guys can get a copy of because you guys are the ones who printed it, that says defects in materials and workmanship you will remedy at no cost to us. Boom. A breach of express warranty. It's not pled here. The implied warranty of merchantability is that an object will do what you expect it to do. And for a vehicle, it's safe and reliable transportation. A vehicle that goes up in smoke and will no longer run is presumably not safe to drive. And it's certainly not reliable. And so you'd be able to make that argument also. But instead, they made the breach of implied warranty of fitness for a particular purpose, which means that they have to actually put into proofs now that they made their needs known and that the seller then stepped up and said, yes, I can meet those needs. The implied warranty of fitness for a particular purpose, though, usually speaks to the seller, the dealership, not the manufacturer. And sometimes you might be able to push it back and get it on the manufacturer. But of course, the person who's buying this vehicle probably didn't speak to anybody at Ford. And the law says specifically that for this to work, you've got to make your needs known to the person you're dealing with, and they've got to be helping you when you rely on that. And so Ford's going to have a very easy time to step away from this one and go, we didn't know. We sell this vehicle with this package, but somebody then took it and modified it, and obviously they never told us what they were looking for. They spoke to people at the dealership, and the dealerships aren't owned by us. They're just people we sell cars to. So if anybody asked me about this complaint before it was filed, they'd say, oh, you're missing 2 counts. Applied warranty merchantability, express warranty. But no one asked me. Deceptive trade practices at count 5, and they're saying that the actions here amounted to Ford and the dealership not providing the benefits that were promised, and a few other things as far as that goes. And so there's a decent allegation we made there that the buyers didn't get what they bargained for. And then finally, the Lemon Law under Ohio, and I pointed this out in my video. I'm not going to get heavily into it. But Ohio's Lemon Law, as most state lemon laws do, has its own definitional section. In that definitional section, it says specifically what a motor vehicle is. And it appears to be an attempt to limit these cases to, in essence, people who buy a car for personal, family, or household use. And so a police department doesn't buy a car for personal, family, or household use. And I'm paraphrasing that only because I don't have it in front of me. But the Ohio Attorney General appears to believe that's what's going on here also, because I found that on the Ohio Attorney General's own website. And the Lemon laws were designed to take care of average people. So they often don't apply to commercial vehicles. They often don't apply to RVs. They often don't apply to motorcycles, despite the fact that a motorcycle is a vehicle powered by a motor that goes down the roadway and is licensed as such. And yet some states go, well, no, it doesn't cover that, just because that's something they decided to exclude. People often ask, do they cover boats? Generally speaking, no. But of course, boats don't go down the road, generally speaking, the way that automobiles do. So that's my take on this lawsuit. On the other hand, if you've stuck to this video this long, I salute you for your endurance, because my timer stopped so long ago, it got bored and fell asleep. So there you go. Questions or comments? Put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. If you could understand Morse code, a tap dancer would drive you crazy.